Welcome to CUTV News Radio, where our hosts Doug Llewellyn and Jim Masters talk to today's top thinkers from all around the world to bring you information, inspiration, and thought-provoking ideas that you can put to use in your personal or professional life right now. Covering a broad range of topics, we dig deep to discover what makes today's top thinkers tick. CUTV News Radio. It's the show where ideas matter. And now, here's today's host, Doug Llewellyn.
Hello, everybody. Welcome back to CUTV News Radio. Today, we're going to continue a discussion that was started last week with one of the top-rated trial lawyers involved in medical malpractice in the state of New York. It was very fascinating, and it's an intriguing subject. If you think you have a problem, some sort of a medical problem, and either a hospital did something wrong in your case, or a doctor, or there are many different possibilities that involve medical malpractice. I should point out that the firm, the lawyer that we're about to talk to, she is in charge of medical malpractice for one of the top personal injury law firms in the city of New York. And she's just a dynamo, let's put it that way. Highly experienced. She's been with the firm for over 30 years, and she represents plaintiffs in malpractice lawsuits who have lost a family member or people who themselves are permanently or badly injured. For example, I know we paraphrased last week when pointed out that the American Cancer Society estimates that nearly 42,000 women are going to die from breast cancer in the U.S. this year alone, and another more than 250,000 new cases of invasive breast cancer are going to be diagnosed. Now, the key to reducing mortality rates for breast cancer is really early detection, no question about it. So it's essential that physicians minimize delays in diagnosis, and sometimes patients delay seeking medical attention after discovering a potential symptom. That's their problem. But when a patient's diagnosis is delayed because they face difficulty getting an appointment with a doctor or scheduling diagnostic tests or getting a definitive diagnosis and then initiating therapy, that constitutes a form of medical malpractice, and it is something that could come under the purview of our guest today, Eleni Coffinas, a top-rated trial lawyer with the firms Sullivan, Papain, McGrath Cannavo, and they are based in New York. They have a number of offices in the New York area, but it is a delight to welcome Eleni Coffinas back to our mics again. She's speaking to us from her office in mid-Manhattan. Ms. Coffinas, welcome back. Nice to have you with us. How are you today?
Thank you, Doug. It's great to be here and to talk to you about this very important topic.
You know, a lot of people don't understand really what constitutes medical malpractice. I mean, they may have a vision of it or some sort of theory, but there are so many different areas that come under medical malpractice. We're talking, well, the list is endless. If we go on your website, which is fabulous and full of interesting information, Trial Law 1 is the website, triallaw1.com. You will see there are wrongful deaths caused by doctor's negligence. We hear about that. But there are medical malpractice during failure to diagnose breast cancer, head trauma, hospital negligence, brain damage at birth. The list goes on and on and on. This is a very complex segment of the law you're involved in, no question about it. Why do you like focusing in this area?
I think that most people are more familiar with other types of personal injury cases, car accidents. Somebody's a pedestrian or a car and somebody hits them because they pass a light or they're going too fast. And we see those types of things on TV, or trips and falls, or even people who get hurt at construction site accidents. I think we're more familiar with that. But medical malpractice, I think people are less familiar with. I like it because it's very challenging. It's, unfolding a story and investigating what happened through reading medical records and through taking the pretrial testimony of all the parties involved. And ultimately, there's a big reward for the lawyer, at least I can speak for myself, in really helping somebody. I mean, we can't take away the physical harm that's been done, but we can get somebody compensated for that harm, and a lot goes into that. That's relief when it comes to medical bills. It's relief when you think about your future or having money for your children if you can no longer work because of your injury. And it's also relief in having won your case. There's some vindication there. There's some, I don't like the word closure so much, but a little bit of a feeling of that I can maybe move on from this. Somebody believes me, and it gives people strength. It gives them the compensation, monetarily, but it also gives them strength to get past a really, really horrible situation in their lives.
And looking at the various lists of things that constitute medical malpractice, first off, it occurs to me that a lot of people may have been a victim of some sort of medical malpractice, but they really aren't aware of it, and they never bring it to the attention of someone like you who are in a position to help them out. Do you think I'm right about that?
Yes, and there have been studies about that. I mean, however many medical malpractice cases there are so many more out there, but people aren't aware of what their rights are or who to go to if they feel that they've been wronged. So anytime, and there are a myriad of different types of cases. For example, last week we spoke a lot about delays in diagnosing cancer cases, and whether it's a man who gets a PSA test, which is a blood test to make sure your prostate is okay, and gets another one and the numbers change, and they changed in a way where the doctor should be warned that there's a potential problem, but nothing is done about it. Or if a woman gets a mammogram and it is not interpreted properly, or if a woman makes a complaint about a lump and is sort of dismissed, which unfortunately women still are dismissed when it comes to their medical problems at times, and is told, don't worry, it's just a cyst, it's something benign. So those are some ways that there are delays in diagnosing cancer. But there are a lot of other cases too. For example, there are what's known as the brain damaged baby case, where a mom is in the hospital and she's being monitored the best way doctors know how, the best way medicine can give us at this point, which is on fetal monitoring strips. And you can see, based upon those readings, whether or not the baby is in potential distress. And sometimes there are variations in these readings, which are, again, a warning sign of a potential problem. And if somebody isn't reading them, or is a nurse, a resident, a doctor, or isn't reading them often enough, or isn't reading them correctly, then what was a very nice and safe home for the baby inside the mom actually becomes a hostile uterine environment. And that baby, by those fetal monitoring strips, is saying, get me out of here. I'm losing oxygen. I can't breathe right. And so that's another potential area where, and then the baby gets born, there is a delay, and that delay could be a half an hour, it could be an hour, it could be hours long, but the baby generally will come out, if it hasn't had enough oxygen for long enough, with some problems neurologically. That's an area, another area, for example, of where malpractice can occur. And sometimes even moms are at risk after birth. And that, unfortunately, happens mostly to, statistically, African American women, where women die after childbirth, but there are signs there that tell you the woman is in trouble, that might need a transfusion, that the woman is bleeding more than you would from a routine birth or a routine cesarean section. And if those signs aren't paid attention to, you have a birth and a death in a very short period of time. Those are two other examples, other than the delays in diagnosing cancer, that are where medical malpractice often occurs.
It's interesting. A lot of times there are medical malpractice cases that make news because of a mistake by a doctor. I mean, you have one at your firm that was handled, and I'm not quite sure how all this was, but it concerns a patient's leg being amputated following heart surgery. Do you remember that case? Was that a mistake? Did the patient go in for heart treatment and they amputated his leg? instead?
That's it's a more complicated surgery. There are complications after surgery sometimes that are not picked up and perceived, and then extremities, legs, arms don't get what they need, in terms of perfusion and blood and that kind of thing. And those types of cases, yes, they end up in the news and people see them, but oftentimes, more times than not, cases end up settling before the time of trial. And so when they settle, many times the doctors in the hospitals will ask for confidentiality, meaning they do not want the settlement advertised, and mostly hospitals do not want settlements advertised because, for obvious reasons, they don't want the public to know that they've made this big mistake and that they're paying all this money for it. So there are many, many cases that the public will never know about because when they settle, meaning they're resolved before going to court, there is often this confidentiality agreement. But the ones that the public sees are the ones where there's a trial and there's generally a jury verdict in favor of, the patient for some really egregious mistake. For example, if you are a member of a group, and many people, because of the way insurance works, are patients not of a particular doctor of their choosing, but they are patients of a group. And the group will have the internist, the podiatrist, like all the different specialties that you need within that group. And I had a case where a woman had a mammogram. There was an alarming finding on the mammogram, meaning that the radiologist in the group interpreted it correctly, but sent it to the podiatrist in the group and not to the doctor who actually sent her for the mammogram. So the podiatrist sees the report, sees it has nothing to do with feet, and does nothing about it. And it just gets filed in the computer system of this group. There are many, many groups like this who have multiple facilities throughout the city. And so it was like another year before, until the patient went back with a complaint, and then somebody looked up and said, well, gee, we had this report sitting here for a year. So people that are patients of a group have a heightened sense of awareness that, everything, communication is not always going correctly. And there should be some level of personal responsibility, meaning to follow up and make sure that you get the results and that you hear or see, better to see even, hey, can you send me a copy of my results? For the patient to do some of their own follow-up when you are a member of a group, because these groups, the system, the way the groups are run, often fail the patients.
Interesting. Describe for me the fundamental root of malpractice. How do you describe? Is it negligence by the doctor? Is it a poor decision making? What really is it, or is it both?
It's both. So there are two factors that you need to have a medical malpractice case. The first thing is the negligence, which could be doing something wrong or failing to do something you should have done. And the standard is, the language used by the courts is, did the doctor meet what is known as good and accepted medical practice? So if I were to ask you or ask anybody, gee, what does good and accepted medical practice mean? You'd probably come very close to the legal definition of it. There is a standard. Doctors don't have to be the greatest doctor in the world, but they have to meet what is considered good and acceptable standard within their own community. So if they have deviated or departed from what is considered good and accepted medical practice, then the second factor comes in, which is, did that deviation from good and accepted medical practice result in a harm to the patient? So, in a car accident case, for example, if somebody is speeding down the road and passes a red light, they've committed negligence. But if they haven't hit anybody or hurt anybody, then there's no what's known as causation. So it's the same thing with medicine. The wrong has to result in a harm. and generally in a permanent harm, because medical malpractice cases are very time consuming. They are very expensive to try. We put out all the funding for the expenses, but they are expensive in terms of getting doctors on board and other things that need to be done. So we don't take it lightly. There has to be a wrong. The wrong has to have caused a harm, and the harm generally has to have some long-standing, devastating implications for the patient. So that's what you need for a medical malpractice case. And in the state of New York, a lawyer cannot start a medical malpractice case for anybody unless a physician has reviewed the case, has seen the records, and has told you, not in writing, it can be verbal, but gives you at least a verbal okay and says, you know what, I suggest that you pursue this case because this is where the doctor did not follow good medical practice. Once you have that green light from the physician, and only when you have that, you can start the case in the state of New York.
You know, most of us are so used to watching court cases on television and how lawyers, work on TV. But we don't see cases like this. They're very complex, as you pointed out. They're very expensive to try. Explain to me to begin how a case ends up in your hands. How does it get to you? Does someone off the street who thinks they have a medical malpractice case, can they call you and you will consider it? Are they referred to you by other lawyers? What's the general rule?
Anybody can walk in off the street, and sometimes that happens. And it's not so much walking in off the street anymore, but it's the Internet, right? So somebody will start Googling or look up a medical malpractice lawyer. That is the equivalent of years ago literally walking in off the street. That's just how people find their information today. And that happens, a decent amount, and we'll always we'll screen people on the phone, and if it's something that we will screen every single case, and we get an awful lot of calls, but we have a big screening system here, so we screen every case, and then we have people come in for appointments, or if they can't come, we go see them on those cases that we think are worthy of pursuit. But otherwise, there are many referrals from lawyers. So there are not that many firms in New York, and we're based in the city, that do a lot of medical malpractice because it is highly specialized. Even if firms do other types of negligence cases, many times they don't do medical malpractice, but they will refer the cases to a firm like mine, because through reputation and through results, they understand it's a good route for their client to go. So that's how cases either come in, either through the Internet, a recommendation of a friend who's generally been a former client, or lawyers that are in different fields or in the field of personal injury but do not specialize in medical malpractice. And that's how it all begins. So as long as the person reaches out to somebody, they should get themselves to a place where there's a firm that's large enough to absorb the costs, experienced enough to deal with the fight that ensues. And there's always a battle, among the plaintiffs, the one who are bringing the suit, and the defendants, which are either hospitals or doctors and their lawyers. So it is important for somebody with a medical malpractice or potential medical malpractice matter to be with a firm that specializes in that field.
Quick question. If a doctor makes a mistake during surgery and a medical malpractice suit comes out of it, is it the doctor they go after, or is it the hospital where the procedure was performed?
So that's an interesting question, and there's a lot of law on that question that's evolved over the years. It depends. So if the mistake is done or the negligence is committed by a resident, maybe it's a teaching hospital, maybe the resident is performing part of the surgery, and frankly, sometimes as the patient, you don't know if you are in a teaching hospital, you don't necessarily know if there is a resident doing part of your surgery. But so if it's a combined effort of your own private attending, meaning a doctor that you've chosen that is performing surgery where there's a resident involved, then they are both involved, the individual doctor and the hospital, because the hospital is ultimately responsible for any acts of negligence committed by its staff, meaning residents, doctors in training, or nurses or the nursing staff. So when I was telling you earlier about a baby case, a mom that's going in to deliver and she's being monitored, it's generally nurses and residents and private attending doctors who look at these fetal monitoring strips. So in that situation, the hospital would be a defendant and the doctor would be a defendant. If somebody comes into the hospital through an emergency room, meaning you're not selecting a doctor, you've got an emergency, you're going to a hospital and you're getting the emergency room doctor that's working that day, and there's a mistake in the emergency room, and there are many emergency room cases where, again, those involve delays. The person needs treatment quickly for whatever they are complaining about, and they're sitting in the emergency room and, sit there and get a heart attack or get a stroke because, they're not getting the CAT scan quickly enough, even though they're presenting with something that would warrant a CAT scan. Under those circumstances, the hospital is responsible because they are the ones that are providing you with the emergency room physician. So the physician and the hospital would be named as defendants in a case like that. And the same thing goes with anesthesiology. Sometimes there's negligence in the anesthesia aspect of surgery. The anesthesia is not administered properly, resulting in neurological damage, brain damage. But the anesthesiologist is not somebody you walk into the hospital and select, right? That's somebody the hospital gives you. So under those types of circumstances, the hospital and the doctor are generally brought in as defendants. But if somebody is going in to have their own elective surgery and you choose your surgeon and you go to the hospital and that surgeon on his or her own just messes up and commits malpractice, then generally it would be the surgeon alone. If the hospital is just the place where it happened and not a real participant.
That's pretty amazing. I know you have to do a lot of work behind the scenes on a case, especially when it goes to trial. By the way, when we talk about going to trial, I gather most cases are settled before they go to trial. Would that be correct or not?
Most are settled before trial or during trial. Most are settled before the verdict comes in. Right.
So, paint a picture for me of the kind of work that you have to do behind the scenes before a case goes to trial. There's a lot of work involved, isn't there?
There's a lot of work involved. One of the things, and the part I actually enjoy most, is really getting to know the client. It's a one-on-one thing with me. We have a lot of clients, but everybody gets that one-on-one attention, which I think is very important, because just through sitting down and speaking to the client, you get a sense of who they are and how can they articulate what's going on, and you learn to ask certain questions to help them articulate better. It's not a comfortable position for people to get up in a court where there's a judge, where there's a jury judging you, and having to tell your story, especially if you're not a public speaker. If it's foreign to many people. But making them comfortable in my office, making them comfortable with the questions that they will be asked, and me finding out what's really going on in their heart. How can they express not just the chronology of what happened or the facts of what happened, but how they feel about it. So that's one aspect, and then that's the personal part. But then once we review ourselves, the medical records, we send them to an expert in whatever field we are dealing with. And if it's a cancer case, it'll be an oncologist, a cancer doctor, for example. And the expert has an opportunity to review the records, and then we have a conversation. And the expert will say to me, well, this is where I think something went wrong. This is where I think you have a case to pursue, or not. And but once we get the green light, then we do the paperwork. And after that, we do what's called depositions, meaning we take the pretrial testimony of everybody. So the plaintiff gives testimony, generally in our office, under oath, with a court reporter, is asked questions by the lawyer for the defendants, and what happened, and basically a lot of factual questions. And then we have the opportunity to take the pretrial testimony of the defendants, which is interesting and challenging because they are doctors, they are educated in their field. I'm not a medical person, I'm a lawyer. I did not go to medical school, and yet I challenge them, and I do so very, very vigorously on where I think they have wronged their patient, my client. And that's a skill that you develop over time. It's more than just saying, please, read your record into our record. Let me know what, to decipher the handwriting, which is often difficult to decipher. It's more than just asking the doctor to spell out what's in the record, but getting into what they were thinking. And for them to realize during that deposition that, their actions did not comport with good and accepted medical practice. And then as you get closer to trial, you meet with the experts, and they educate you on the medicine. You educate yourself on the medicine through means other than, in addition to the experts. And then, you physically prepare for trial, getting your records ready. Sometimes we have what's known as demonstrative evidence, where we blow up or enlarge either diagrams or parts of the record that we really want the jury to focus on. So, it goes on and on. There's a lot. Then there's the whole, which is a topic for a whole other conversation, the skill of doing a cross-examination of a defendant or of their experts to get them in a position where they're saying, I think I'm in trouble here, maybe I will settle the case, or to have the jury, believe in what you're saying so that if you don't settle the case, you will win the case. So there's a lot that happens.
And it takes a lot of time. A lot of time can be invested in this case. These cases, they don't come and disappear over a month or two. They can last considerable amounts of time, right? They
last some years, not a lot of years. I try to move very quickly. The courts are not that quick because they're inundated with all types of cases. But yes, all that pretrial work, exchanging records back and forth, doing all these depositions, and sometimes, depending on the case, you're taking the testimony of nurses, of residents, of doctors. You're taking a lot of testimonies. Sometimes the defendants, in addition to the plaintiff, will want to take the testimony of family members who were involved with the care. So yes, that takes a period of months. Once you're ready, once you say to the court, okay, we've done all of our pretrial work, we are ready for trial, then the court says, okay, now you wait. Because then once you are trial ready, you have to wait for the court to be ready for you, for the court to have finished the cases that come before you.
A lot of time.
It needs patience, but it's worth it.
You are amazing to talk to. I wish we had an hour at least to go through this with you. We've been talking with Eleni Coffinas. She is a top-rated trial lawyer and the partner in charge of medical malpractice for Sullivan, Papain, Block, McGrath, and Cannavo, one of the top personal injury law firms in New York City. You've been doing this for a long time. You obviously are very good at it. You love what you do? It sounds like you do. It's very interesting. I
hope so. After I've stuck with it for more than 30 years because I am still super passionate about it.
And, somebody might, what's your record when you go to trial, in cases like this? For the most part, do the lawyers win? Or is it varied?
Depending on the county, it's very tough for plaintiffs to actually win the medical malpractice cases. There are some counties that are conservative and more doctor-oriented. There are some counties that are more patient-oriented, and so it's an uphill battle, honestly, it's for tough. Any plaintiff. Yeah, it's tough, but you have to know what you're doing. You have to have the experience, and really you have to have the guts to just keep going.
We've run out of time. Thank you so much for your time. This has been great hearing from you again. Eleni Coffinas, and their law firm website is triallaw1.com. triallaw1.com. If you think you have a medical malpractice case, go there. That's it for today, everybody. I'm Doug Well, thanks for being with us. I found this fascinating. I hope you did too. Very, very interesting. See you next time. Till then, take care of yourself. Bye for now.